I'm Jennifer Moore with Marcelino Moore, and I just spoke with Deb Dilman, one of our attorneys here, about the collaborative process in divorce. We talked about what it is, what it's not, who it's good for, who shouldn't do it, and how to find the right attorney if you're interested in the collaborative process and may want to go that route. So take a look at this video. I hope you enjoy it. Okay, Deb, you are a collaborative practitioner. Primarily prefer, if I'm accurate here, to handle cases collaboratively, right?
Yeah, so for me, I'm a problem solver, not a litigator. So I do litigate. I'm good at litigation. I don't love it, but I do my clients. I try to resolve things outside of litigation, and I am a collaboratively trained practitioner, and then I'm also a certified mediator.
And so let's talk about what the collaborative process is and is not, because I do think sometimes people aren't quite understanding of what it is. And so I think it'll be interesting to hear from you you are a true believer in the collaborative process, and you've seen it work for so many people. So tell us what that looks like.
Yeah, so the collaborative process was codified by statute in North Carolina years ago, and it's morphed since that time. The collaborative process statutes have not changed. There's a family law set of statutes, and there's also civil statutes that address the collaborative process. But to be a true collaborative case, the parties agree that they are not going to go to litigation, that they're going to treat the process with respect and integrity, and discuss issues related to interests and fears versus various legal positions. And in order to be a truly collaborative case, there is a participation agreement that both clients and attorneys sign, actually outlining those principles. And so for me, that's a collaborative case. Everything else for me is cooperative.
So let's talk about what's in that collaborative agreement that everyone signs. There's a very important piece to it that I want to make sure everybody watching understands.
So the collaborative agreement outlines that you're going to treat each other with respect, trust, openness. So we're going to be readily exchanging documents that if you were in a litigation mode, you would not necessarily be exchanging. You would be forcing the other side to do formal discovery or depositions or just hiding information as you prepare for litigation. But we're agreeing to do that. That's all in writing, and we sign that agreement. Within the body of that, because we are being transparent with everybody, including the attorneys, you are signing away your right to use those same attorneys if the case ends up going to litigation.
Okay.
And that is a tough pill for people to swallow.
Yeah.
But over 90% of collaboratively signed participation agreements resolve.
Interesting. I didn't know that stat.
So you're just talking about a very small percentage of those cases. That also means, though, that you have to choose the right clients to enter the collaborative process.
Yes, I agree with that. It's not right for everybody.
It's not. They used to say it was, and there's research out there that from some people that will say it works in domestic violence cases. I don't adhere to that philosophy. I think there are cases that it works for, and there are cases that clearly are not for the collaborative process.
So obviously, domestic violence cases, it cannot work for, but are there other types of clients that you would say the collaborative process is not for you?
Yep. So domestic violence, the most understood domestic violence is physical abuse.
Sure.
What we are learning is that the coercive control and power imbalance in a relationship is probably happens more often than people discuss. So that coercive control, power imbalance, that's domestic violence as well. We don't call it that necessarily, but those cases are not going to work in the collaborative process because there is that imbalance there. Unless you get a terrific divorce coach involved that can work with the person with both of them actually.
Sure.
And that normally doesn't happen. Other cases where collaborative will not work is when one of the parties clearly understands or believes the process to be something where they can withhold information because it's not in litigation, so it's not public.
Yeah.
Those become difficult to deal with as well.
Yeah. So let's kind of flesh that out more. So you talked about the collaborative agreement being one where you agree that you were going to be forthcoming with everything.
Mm-hmm.
And, compare that to the litigation process, as you were talking about, where to get what I want, I've got to force it out of people. I've got to force it via discovery. I've got to force it via subpoenas, depositions, things of that nature. And I have to artfully obtain it because people are trying to prevent me from obtaining it generally.
Right.
But in the collaborative process, the idea is that everything is on the table, that all information is provided freely when it's asked for, that nothing is hidden. There is no art to it. It is an open book.
That's right.
And if you aren't able to do that or unwilling to do that, then the collaborative process is going to fail.
But yeah, I mean, if you're not willing to do that, there's no way the collaborative process can work.
Correct.
And so people need to understand that. And again, if you've got the attorney that has a lot of control over what that client, and there's the reasonableness there,
Mm-hmm.
and the expectations are set, then yeah, maybe you could get there. But there are some cases where they're not going to be willing to disclose information, or they think the way they need to do everything is just to move all their money around and no one's going to find it.
Right.
Well, that won't work.
Yeah.
Regardless, we'll find it. You're going to find it whether it's collaborative, or you're going to find it whether you're in litigation or cooperatively trying to negotiate a settlement.
Yeah.
You just can't hide this stuff.
Exactly.
Cash you can hide, but other than that.
Well, hopefully people aren't stashing cash under their mattresses. Yeah, and I think you're right about the power imbalance. That's often something we see, and if that is so significant that one of the spouses is kind of, for lack of a better term, beaten down in that
Mm-hmm.
way, and the dynamic has always been that one person is so much more subservient, it can't work in that situation.
That's right, it can't. And most of the time, when you're talking about the course of control, most of the time, not always, it is around financials.
Correct.
That
Yes.
one party is just keeping all the financials from the other one. And so if you think about it holistically, how do you ever fix that in the collaborative process?
Yes, it's so embedded in
right.
their relationship for sometimes decades.
Correct.
There's no undoing that.
That's
yes.
right. Yeah.
Okay, and then let's also talk about the preventing the attorney from litigating.
Mm-hmm.
So when you sign that agreement, when a party signs that agreement, the attorney also signs the agreement.
Mm-hmm.
And everybody understands that the attorney that has been hired for each party cannot take the case to litigation if the case does not resolve in the collaborative process.
Yep, that's right. It's not just the attorneys that have been hired, but if you bring in, because you're allowed to bring in professionals to help you in in certain aspects of the case. You can bring in a divorce coach, which is typically a mental health professional that's not giving therapy, but is actually helping the parties work through the divorce. You can bring in a child behavioral specialist, which might be listening to the children and then trying to work with the parents. But if you bring in any kind of specialist, a financial specialist, those specialists will also be excluded or precluded from helping in litigation if you're unable to resolve the case. But remember, only 10% of those cases end up failing.
Yes. And so that is such an important piece of the collaborative process that everybody has to understand. And it's good skin in the game for everybody, because the idea of, having to start over with a different lawyer is daunting for people and sometimes cost prohibitive.
Yep.
And so it's definitely good skin in the game. But also, if it's a situation like a power imbalance, like you were mentioning, and you sign that agreement, it can be devastating for especially the party that is the one with less power.
Yep.
So it's important to understand that and to make an educated decision. And I think that there are lawyers in town sitting at this table who practice this differently, or their practice is different. And it's important, I think, for people to understand that they should, if they're considering the collaborative practice, talk to a lawyer who is elaboratively trained and practices the collaborative process truly like you do, and there are others in town, and then talk to lawyers who don't practice in the same way and understand what's best for you as the party going through this, based on all of those factors that we've just talked about.
Yeah, in my consultations, I typically talk to folks about the continuum, right? Like on one end of that continuum, you have talking with your spouse at the kitchen table and trying to resolve things on your own, and then just coming to an attorney to try and formalize everything in an agreement. And there are few cases out there where that happens.
Sometimes.
And then at the other end of that continuum is litigation, right?
Sure.
And then in between, you have all these other creative options that you can come up with. One of them might be mediation without attorneys. One of them might be mediation with attorneys. One of them might just be straight up negotiations between attorneys and clients. And then the collaborative process is just one other process that people can enter into.
Right.
But good attorneys in their consultations are going to describe all of those things.
Exactly.
And
I think we both do.
Absolutely.
And I certainly think most of the attorneys in our office do that. Not all are collaboratively trained, but we're able to explain all of that to our clients.
That's right. You know, the collaborative process is codified by statute. It is a particular process. But generally speaking, if you're anywhere between those two bookends, you're just being cooperative with one another.
Yes.
And the attorneys, right?
Yes.
The attorneys are involved at some level. It's not just you, typically. And so I think that's important for people to know. But people sometimes like the collaborative process because they want that investment to know that they do have to start over again. So they dig deep. They think hard about their next steps because they do want it resolved without litigation, but they don't want
the skin in the game.
Mm-hmm.
Yeah, it's important.
Yep, it is.
Yeah. So let's talk about the true collaborative process, what it actually looks like once you sign that agreement.
Mm-hmm.
And then let's talk about the cooperative process, what you were just touching on.
Mm-hmm.
But, before we even get there, we were talking about the varying attorneys in town. So when you're looking for an attorney, there is a website that directs you to the professionals in Charlotte who practice collaboratively, some more so than others, but it's Charlotte Collaborative Divorce Professionals.com. Is that right? Or
Yep, it's right. It's
okay,
nice and long.
It's a long
one.
Yes. So you can check out the lawyers there. But again, when you're meeting with them, you'll get a sense of, are they going to do a true collaborative process? Is that something that they typically practice? Or do they typically practice only litigation, and why is their name up on this website? Or do they do more of the cooperative? And I think there's the wide range on that website, and you can find both of us on that website and others in this office, and some really great lawyers in town there.
Yeah, there's great lawyers in town, but that website, it's professional. So it's not just lawyers. It's
Correct.
a whole group of mental health professionals and others who have been trained to be divorce coaches. It's our financial neutrals, and it's also our child behavioral specialists, and some of those cross over.
Yeah.
But it's also a good way, even if you're not going to sign a collaborative participation agreement, if you know you need a financial person, it's also a nice way to find somebody who's had some additional training in dealing with the financial aspect of divorcing couples or separating couples.
That's a great point.
Yeah, so it's a great website. Some people use it more than others. I know for me, I sometimes refer folks to the website, but I also refer folks to other attorneys that I know I work well with.
Yeah.
I won't just give one. I usually give, you try 3 or 4. I think that we're required to do that by our canons, but I do that, and I think others do that as well. But yeah, so the process, once you sign a participation agreement, is, you have a meeting to welcome everybody to the process. You go through the participation agreement to make sure everybody understands. In that first meeting, you talk about any pressing needs that need to be addressed, like maybe there are children issues, a school issue, or something that needs to be addressed. And then you discuss what financial documents we need to gather and how we're going to do that. And then, we set a timeline to come back to discuss as a group what else we may need. If we don't need anything, then we might just jump right into brainstorming. But that brainstorming is different than preparing for litigation. So the brainstorming is, okay, what are your interests? What are your fears? What can we brainstorm about that's going to help you get what you want or alleviate your fears? And of course, the fear mostly is about money or the children.
Sure.
And so working through those issues, but you just brainstorm options and then you leave. And I'm being very simplistic here, right? There's a lot more that goes on, but then you leave and you contemplate, ruminate about those, and then you come back and maybe narrow them down to 2 or 3 and you talk about those as a group, and then try to reach an agreement. The other part of the collaborative process, since it is an out-of-court process, is you have an opportunity to just enter into what we call a separation agreement, which is a legally binding contract. It's just not filed with the court to resolve all your issues so that you don't have to worry about the public seeing anything.
And so that's the outcome, ideally, is a resolution that results in a signed separation agreement. Sometimes it results in a signed consent order for custody that does become a public court order.
Yes.
But the goal is all of the documents that resolve everything were derived by mutual agreement.
That's right. That's right.
And backing up to the meetings, so it's important to understand that they are joint. You and I just talked about mediations where everybody is in separate rooms typically after that joint session. But in collaborative process, it's different. You are coming together for joint sessions. So the spouses are in the same room along with the attorneys and any third-party professional that's hired. But we do typically tend to keep those meetings shorter. You're not in there for an entire day. It's typically an hour or 2. And there's an agenda ahead of time with the idea of what we're coming to discuss and what we're coming to resolve.
Yeah. And so that's exactly right. And then before each meeting, in a pure collaborative case, the professionals involved, so the 2 attorneys, and if there's a divorce coach or child behavioral or a financial, they'll meet to pre-brief what's going to happen in the meeting and probably work on the agenda together. And then there's always a debrief because, not all those meetings go smoothly. There's a lot of people that think it's just a bunch of kumbaya, and it's not. Collaborative cases are extremely difficult because they tend to allow more of those emotions to surface. So you're dealing with that, and attorneys are really not equipped to deal with emotions very well.
That's a good point.
And so we always pre-brief and debrief. Which is helpful in collaborative cases.
Yes. And so each meeting, maybe you're just touching on temporary custody in one meeting. And then maybe the next meeting you're touching on temporary child support. Right. And then you have professionals. You don't always have to have these other professionals, but like you mentioned, a child specialist. Sometimes if you want the voice of your child heard in that situation, that might be where that person comes in. Or a financial neutral, somebody who can present ideas for spousal support or child support in a neutral way so that nobody can hopefully buck up against it.
That's exactly right.
Or present a method of division of the estate, a couple of methods, hopefully, some options for that for everybody to work through. So there are these other professionals that can come in and help, and you'll rely on your attorneys to decide, do I need these other professionals and to what extent?
Right, exactly.
Yes. And if you have 2 good attorneys who are well-versed in the collaborative process, sometimes you don't need a divorce coach. If everybody's emotions are even-keeled and the attorneys can help guide the process and create the agenda and all of that, you don't need a full team all the time.
Yeah, and I said earlier when we first started talking that the process has morphed a bit, right? So when the collaborative process first came to be in North Carolina, it was always you had a full model. So you had to have 2 attorneys, you had to have a divorce coach, you had to have a financial neutral, and depending on if you have children, you may or may not have to have a child behavioral specialist. And what we have learned is that while having all those professionals, if we can get it resolved, is still less expensive than protracted litigation, it is expensive to have everybody in a full team. So now it's morphed to, all right, let's really look at where we are. Maybe we don't need a divorce coach because these guys get along okay. Maybe we don't need a child behavioral specialist because there's either no children or they're in line with one another about how parenting should happen. So what we see a lot of times is we have financial neutrals just to help with the bigger estates to try and ferret out what's a reasonable distribution of taxable monies versus non-taxable monies so that everybody's getting something that they can live with. Or you might have a divorce coach if you've got someone who just doesn't really want the separation but knows it's happening versus someone that's ready to move on. And that can be hard when they're on separate pages about that.
Right. So you start with the lawyers, and then the lawyers can guide
Mhm.
the parties and jointly decide, are we going to hire anybody else,
Yep.
or can we keep this just us?
And then also, so we didn't talk about this, but we hit on it a little bit. So the collaborative process in signing that participation agreement and indicating you're never going to go litigate with these same attorneys does not mean if you reach an impasse on something that you can't take it to a mediator.
Oh, good point.
So you can always bring in a mediator who also is not going to make a decision for you. So it's not like litigation, but a mediator can help facilitate a resolution between everybody, either on the whole thing if you reach an impasse or on one or two specific things.
Yeah, exactly.
Nice.
So that's the next step potentially. If you want to stay out of litigation, but you can't resolve it in the collaborative process, and then you can have different attorneys represent you in that mediation. And then, of course, if that doesn't work, then the only other option is litigation. But oftentimes I see in litigation cases where we litigate some and then we resolve down the road.
Yeah.
So just because the collaborative process failed initially or mediation fails initially doesn't mean that you're going to have to litigate every single thing for the entirety of the case.
That's exactly right.
Yeah.
And if you do mediation within the collaborative signed participation agreement, you're still using those same attorneys. So those attorneys don't have to get kicked out unless you also reach an impasse in mediation, which again doesn't normally happen because if you've entered in the collaborative participation agreement, you have two parties who really, really want to settle it outside of litigation. So usually if you can't get it done amongst yourselves, a mediator will get you over the finish line.
Yeah. So then the last thing we've talked about but haven't fully explained is the cooperative process, as we've termed it. And I think that's kind of the generally accepted term, at least in our community now. And it's people who want to work together to resolve their separation and their divorce do not want to litigate, but don't want to sign that collaborative participation agreement. And maybe it's because of that power imbalance. Maybe it's because they're terrified to let go of their lawyers. Maybe, I don't know, there's a million reasons why you wouldn't want to do that formal agreement. But you have two lawyers who are on board to try to collaboratively or cooperatively work together and resolve it ideally outside of a courtroom. I tend to be more of a cooperative attorney if my client wants me to be, whereas you prefer the more formal collaborative process. I typically don't. I like the idea of being able to represent my client in any way he or she needs, whatever is best for him or her. And if that means the cooperative process, great, I'm all in. If that means mediation, great, I'm all in. Or if that means litigation, I'm all in on that too. And I think there are attorneys, not just at this table, but in our community as a whole, who have your method of practice, which is more strictly collaborative, and my method of practice, which is all of the above. And so in that cooperative practice, I have a case right now where I have a collaboratively trained attorney on the other side. I myself are collaboratively trained, and we have agreed we're not going to sign the agreement, but we hired a financial neutral and we set mediation for a couple of months from now. And there aren't children, so we didn't have to do much for the parties other than allow them to get set up with a financial neutral who can then put together options for support and property distribution for us to consider. And then we're going to come to the table at mediation and work through that. And I'm very hopeful for resolution because these people do want resolution outside of a courtroom. So there are options, and there are attorneys in town for any option that may fit the bill best.
Yeah, I think that what law school fails to do and what some of the practice firms in town fail to do is to teach these young attorneys coming out that there is a myriad of options available to you, that it doesn't have to be litigation or nothing. And so, yes, I prefer, if someone wants to do collaborative, I prefer to go ahead and sign the collaborative form. But if someone comes in and just says, I don't want to go to litigation, I've got a couple clients right now, I don't want to go to litigation, what are my options? Well, you're not a candidate for collaborative, and here's why. So I do that as well. But I think we do a really bad job at explaining to attorneys that all of these options are always available to your clients, right?
Yeah.
That it doesn't have to be, I'm just going to go do litigation and nothing else, which is all cooperative.
Sure.
Until you get into that, either arbitration or litigation, it's all about working together to reach a reasonable resolution that both parties can deal with, sleep at night, and move on.
Yeah. And so I guess on that note, it's important for anybody watching this to interview your attorney well and understand what that attorney's typical practice is like, and also know your goals and motivations and highest priorities, and ensure that all of that matches with the person that you're hiring to help you.
That's the best point, right? Yeah. Is you need to be strong enough with your attorney to be able to say to your attorney, this is what I want, which goes back to what I said in an earlier podcast with an attorney that mediated a case for me that I didn't think was ever going to get settled. The first thing she asked both parties, what do you want out of this?
Right.
What do you want?
And as long as you can match that desire with your attorney's way of a method of practice,
that's right,
then you should be good to go.
It should be great.
Yeah.
Yep.
Okay.